that he resided in the room that the narcotics were found in, him and another individual, the co-defendant. There is nothing that says that he intentionally exercised control over those drugs. Originally, he was charged with possession with intent to sell cocaine. The state upgraded the charge to trafficking of fentanyl. I didn't see anywhere in the arrest report. Obviously, I don't have discovery. Ms. Rivers represents him in that case, and we didn't realize, we couldn't see anywhere in the arrest report why it was upgraded. But we are asking, based on the fact that there is no evidence that Mr. Robinson had knowledge, dominion, or control over the narcotics or contraband in this case, that his bond be reinstated in these matters.
The state objects for several reasons. The reason why the charges were updated in the latest case is because FDLE came back positive for fentanyl and not cocaine. So based on the weight, both co-defendants were charged with trafficking in fentanyl, which carries a 7-year minimum mandatory. He is also charged in a very first case with possession of firearm by convicted felon and paraphernalia. On February 5th, 2023, was arrested and later charged with that case and improper exhibition of a firearm. He had a firearm. While he was out on bond on that case, he committed burglary with battery and aggravated battery with great bodily harm. The bond on the previous case was revoked at the time when he picked up the aggravated battery and burglary with battery, which is punishable by life in prison. However, this court reinstated it, notwithstanding the seriousness of the aggravated battery and burglary, and allowed this defendant to be again out on bond and commit other crimes again. What's very important to note on the latest case, when the law enforcement went to serve the search warrant, the fentanyl was in the bedroom that was shared by Mr. Robinson and co-defendant Destiny Jackson. At the same time, in the bedroom, there was an infant son of Destiny Jackson. I've received information from DCF that they want to pursue the case because they're seriously concerned for the safety of the child. At the same time, in the same room where the two were staying and the child was staying, there was a loaded firearm that was found.
Well, I'm going to leave the bond the way it is. Thank you.
Thank you.
All right. Your Honor, he also has arraignment this afternoon with Ms. Rivers.
That's correct, Your Honor. 24 CF 1682, number 44 on the afternoon docket. We would tend he's
Charged with what?
he is charged with trafficking fentanyl, possession of a weapon by convicted felon, possession of narcotics equipment. We're going to tender a not guilty plea at this time and request trial by jury.
All right. Thank you, sir.
And the court date would be 10/28, Your Honor?
Yeah.
Thank you, Your Honor.
All right. This is Destiny Jackson in 24 CF 852. We have a motion to reinstate bond in her case.
Same facts as I
Same
just
facts,
heard.
Your Honor.
No, bond's going to be same revoked.
All right.
Thank you.
Yeah, we can do that.
She also has arraignment this afternoon.
Judge, I'll go ahead and enter a plea of not guilty on her behalf. Trial by jury.
What's she charged with? Trafficking fentanyl?
She's got a trafficking in fentanyl, possession of firearm, ammunition, or electric weapon by convicted felon. The possession of fentanyl is a first-degree felony. Possession of firearm or weapon is a second degree. And first-degree misdemeanor possession.
All right. October 28th.
Thank you, Judge.
Thank you.
Your Honor, that's all I have.
All
Thank you.
right, thank you. Good morning. David Rear.
Your Honor, for the record, David Ware, I got Grayson Clark, inmate. Thank you. And Your Honor, if I got to have a moment, we had an update from the state for the offer. All right, ignore the cross-town stuff.
My apologies.
He said you're dropping the charges?
The violation of probation.
He's gonna admit.
Oh, okay.
It was an option.
I can't read that.
Your Honor, we've reached a modified agreement with the state in 22 CF 2206 violation of probation. Mr. Clark would enter an admission to violation to be adjudication of guilt, revoke and termination of probation, $100 cost of prosecution, $50 VOP fee. He'd have 90 days to pay any outstanding monetary owed to the clerk of court. May I approach?
Clark, could you please raise your right hand and be sworn? You swear the testimony you give for his court's true, so help you God?
Yes, sir, I do.
The state of Florida versus Grayson Clark, 22 CF 2206. You want to admit that you violated probation?
Yes, sir.
Did you read and sign this admission form?
Yes, sir.
You aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
You happy with the work Mr. Rear's done for you on your case?
Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it. Judge you guilty, revoke and terminate probation, $100 cost of prosecution, $50 VOP fee, 90 days to pay it, or monetary, it goes to a judgment.
Yes, sir.
Okay?
Thank you, Your Honor. That's all I have.
Thanks.
Flowers, morning.
Good morning, Judge. I have Mike Hilton Lett on the docket today. Your Honor, the state is agreeing to put this on for Tuesday. Docket day, we have a last piece of discovery that I'm going to review with Mr. Lett and for a plea.
What?
Right after this.
Okay. Thank you, sir, Mr. Lett.
Your Honor, this is Jennifer Flowers with RCC on behalf of Terrence Parker. Your Honor, we're here on two violations of probation cases, and they are case number 24 CF 1239, 23 CF 1799. We'd like to enter a denial today and set on, I tried to get him on for a bond hearing this morning. Looks like it didn't get set on the docket, so if we could set him for his bond hearing on the 5th.
September 5th?
Yes, Judge.
All right.
I'm gonna go. Thank you, Judge. I believe that's all I have. Might be excused.
Go ahead and call him out.
Philip Okaloosa. Philip Okaloosa.
What's he here for? No bond, Capias.
Jennifer Brumbaugh.
Hey, come on up here. You hear Ms. Brumbaugh on a violation of probation. Is there an offer from the state?
Yes, Judge. The offer from the state is to modify probation for 6 months so she can complete a new substance abuse evaluation and treatment and attend 4 AA meetings per month. So it'd be an admission to modify probation.
Want to accept that if you is it an extension of probation?
Yes, Judge.
If you want to enter an admission that you violated probation, you don't have to if you don't want to. But if you want to admit that you violated probation, I'll give you a sentence of modifying your probation to extend it for 6 months.
You'd extend the 4
Extend
years
it.
for 6 months?
Yeah, give you 6 more, extend it out for 6 months, your probation. And you have to attend 4 AA meetings, is it a month?
That's correct, Judge, for the 6 months.
Yeah, for the 6 months. You want to admit or not?
No.
I'll appoint public defender to represent you and set you for, when's our next VOP hearing dates? Pardon?
I don't live here.
Where do you live?
I live in Palm Coast.
Palm Coast?
Yes, sir. Is there any way I can attend these things via Zoom? Because it costs $600 to come all the way up here.
That's too bad.
Okay, then I'll accept the plea then,
I
because
mean,
I
I'm
can't
not
afford to come
forcing
back.
you. You don't have to accept it if you don't want to, but you got to come in person. All these other people come in person. I don't even let attorneys appear by Zoom unless they're dying of cancer.
I can't afford to come back, so I'll accept the offer.
If you raise your right hand to be sworn, you swear the testimony you give for this court is true, so help you God.
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Anyone force you or threaten you to cause you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Court finds the admission is freely and voluntarily entered. Court accepts it. Will extend your probation, modify and extend your probation by 6 months. Order you to attend 4 AA meetings per month. Okay, is that it?
Substance abuse evaluation and treatment.
Yeah, to have a one substance abuse evaluation and then do any treatment they recommend. Okay? Thank you.
And approach Judge, have a score sheet.
Yeah.
Your Honor, he is scheduled to terminate probation January the 2nd of 2025. Are we going 6 months from there, or we're going 6 months from today?
From there,
Yeah. Otherwise, it's just a 2-month
Okay,
or
so
whatever.
6 months from original termination date of
Yeah.
1/2/25.
Yeah.
Okay, thank you.
Two pro se in custody, and then another party notice is ready to go as well. He is going out.
Mr. Nopes?
I only got one case, and what I was gonna ask,
All right.
Judge, I've got an appointment tomorrow afternoon to speak to Ms. Leone about some other cases. So I was gonna ask if I could just put this case on for Tuesday. We're anticipating a plea. I just want to talk with her. I've looked at the score sheet. There's some issues that I've got a question about, and I know she's been out, I've been out, and I've got to meet with her. I've already set it up to talk to her tomorrow afternoon.
Who is this now?
Erin Jefferson, I'm sorry, Judge, I didn't even announce.
All right. So you wanted to have this on September 5th, you said, or 3rd?
Whatever Tuesday is, Judge,
That's
the 3rd.
docket day? All right, let's get this done because Mr. Jefferson's been to court about 50 times.
Judge, I agree, and I've got the report from Dr. Harper. I just need to get with the state, discuss the
All
score
right.
sheet.
All right, we're going to try to get your case figured out, okay, Mr. Jefferson?
Yes, sir.
And come back on Tuesday, September 3rd, and it looks like Mr. Nopes will be able to get your case resolved, okay?
Thank you, Your Honor.
Thanks for,
Thank you.
I'm sorry you've had to come so many times,
Okay. I
but
appreciate it.
they're just trying to do the best for you, okay? All right, thank you. Okay.
Thank you. Judge, I've got the two pro se in custody. Be Livingston. Come on out, please, sir.
All right, this is 23 CF 2284, State versus Michael Livingston. Mr. Livingston, you're here on a violation of probation. Is there an offer from the state?
The state would adopt whatever probation's recommendation for Mr. Livingston is. I don't have it in front of me.
In my dealings with Mr. Livingston, Your Honor, Department of Correction sentence would probably be appropriate.
So that's what it's gonna be.
What did he do? I mean, well, let's just,
What's alleged, Judge, is obviously he was on probation and then allegedly violated a DV injunction,
violated
a
what?
domestic violence.
Yeah,
injunction.
what is he looking at as far as a Department of Corrections type sentence?
I did the score sheet this morning, Judge, and it came out to 54 months, 54.75.
I'm going to appoint the public defender to represent you,
Thank you.
okay? So,
Judge, at this time, I'll just enter a denial on him.
Okay.
And I'll come out to the jail and see you once we get the file open.
and we'll set this for, what's my VOPs, Ms. Hannah? September 26th, okay?
Thank you, Judge.
All right,
All right, sir.
okay, thank you.
David Stanley.
All right, Mr. Stanley, you're here on a violation of probation. Is there an offer from the state?
What's the case number, Your Honor?
It is 20 CF 2243, a violation of probation.
I don't have it on my docket, Your Honor. Me neither. Yesterday afternoon? Oh, well, okay, I can try to locate the case.
We can bring him back this afternoon if you want to.
If I cannot locate it right away, then I did.
I've got arraignment this afternoon. Bring him back this afternoon to make sure.
That's fine. Thank you, Judge.
Yeah. Thank you. We'll bring you back this afternoon.
Yes, sir.
Mr. Powell, you got a case? Yes, we got it.
Good morning, Your Honor.
Morning.
Dixie Dan Powell on behalf of Jason Miles. And this case is, he's in that treatment program in the county jail, and we continued it last month. I think he had 9 months, so we were going to continue it again for him to complete that program. If we could put it like in November, December docket.
What about November 4th docket day? November 4th, how about that?
November 4th.
Is he here?
Yeah, he's,
Yeah.
I got to figure out how many more months he's got left, and then we're going to sentence him when he completes his program. Unless I can talk to the state into letting him do another 1129 program.
I can suggest that I would be agreeable if he waived the credit and do a full 1129 in the jail
Next time?
next time.
Yeah,
So he can complete now until November, and then he can start the 1129.
perfect. We'll put that on the record, and we'll do an amended plea agreement, Judge, to reflect that, or just amend the sentence, whatever.
All right. So do you want to bring him back in November then?
Yes, sir.
November 4th?
Yes, sir.
Okay, thank you,
We should
sir.
probably go ahead and sentence him on November 4th, just to complete the program, and then a consecutive 1129.
All right, that'd be fine.
Yes, sir. Okay. Thank you, Your Honor.
Okay, thank you, sir.
Thank you.
Thank you. God bless.
Okay.
Yeah.
I
have a few out of custody, Your Honor, if I may.
All right.
Your Honor, first I have Mr. Stephen Bolden. Your Honor, Mr. Bolden is present and approaching. We've reached an agreement, if I may approach.
All right. This is 24 CF 698, State versus Stephen Bolden. Mr. Bolden, would you please raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God?
Yes, sir.
All right. You want to enter a no contest plea to the charge of burglary of an unoccupied structure, a lesser included offense, and the state's and also to misdemeanor battery, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count one, charged with, this is a downward departure. Court sentenced you to 18 months probation, adjudicated guilty, $100 cost of prosecution, $767 court costs, $150 PD fee. No contact with Diana K. Crandall, no trespassing at Diana K. Crandall's residence, had taken anger management class, enrolled within 30 days. Count two, judge guilty, sentenced you to time served. Okay?
Thank you, Judge.
Thank you.
Ms. Bolden, I'll need your fingerprints, and I'll send you probation notice, please.
Next, Your Honor, I have Miss Deborah Corey. Your Honor, Ms. Corey is present and approaching. Judge, this is 24 CF 1491. If I have an agreement, if we may approach.
Okay. Ms. Corey, would you please raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God.
Yes, Your Honor.
You want to enter this is State of Florida versus Deborah Ann Corey, 24 CF 1491. You want to enter a no contest plea to possession of a controlled substance, a third-degree felony, correct? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
The court finds the plea is freely and voluntarily entered. Court accepts it, sentences you to time served. $100 cost of prosecution, $515 court costs, $150 PD fee, all due within 180 days or reduced to a judgment.
Thank you, Judge.
Thank you, Judge.
Next, Your Honor, I have Mr. John Dennis.
Adjudicated guilty for Ms. Corey.
Yes, thank you, Judge.
Your
Ms.
Honor,
Corey.
real briefly on Mr. Bolden, we request that supervision fees be waived.
All right.
Yes, thank you.
Sorry.
Your Honor, Mr. Dennis is present and approaching. This is 23 CF 2612. If I may approach, we have an agreement.
Mr. Dennis, would you please raise your right hand and be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes, sir.
This is State of Florida versus John Monroe Dennis, 23 CF 2612. You want to enter a no contest plea to the charge of fleeing and attempting to elude a second-degree felony. Is that correct? Mr. That's what he wants to plead to?
Yes, Your Honor.
Mr. Dennis, did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, withholds adjudication. Sentences you to 2 years probation, $100 cost of prosecution, $415 court costs, $150 PD fee.
Thank you, Judge.
Okay?
Based on the public offender, we request that supervision fees be waived.
Yes.
And for the record, Your Honor, that plea was also done in consideration with that withhold. I don't believe that'll affect his driver's license. He's trying to get a CDL later today. So in the event that that does affect his license, we may have other motions that we file to try to come back and revisit so that his license is not affected.
Well, I mean, I don't know how I withheld
Yes, Judge, and that was just for the record, in the event that his license does get affected by DMV. That's just for the record. Thank you, Judge.
Any more, Mr. Gibbs?
I don't have any other out of custody at the moment, Judge.
Well, we'll go ahead and take in custody, I guess. Do any of y'all out here have cases? You have attorneys? Who?
I do.
Weathersby?
All I know is they're not in our jail.
Yes, yeah. She paid her bond and then Walton County came and took her.
As it happens.
All right, well, let's start with Mr. Gibbs.
It's fine with me.
I know this gentleman is covering for Mr. Henderson, but when he was not. First one should be Alford.
Okay.
Got it. Your Honor, Tim Gibbs on behalf of Ms. Regina Alford. Judge, this is 24 CF 1313. We're here for a motion to reduce or modify her bond. Judge, she's been in jail since June 4th of this year. She's got 11 counts involving animal cruelty. The bond was set at $5,000 each count, so a total of $55,000. Judge, she is unable to make that bond. We are requesting an RWAR signature bond. She's lived in the area for her entire life at Harris Street. She only actually makes about $928 a month in disability payments because she is disabled. She's unable to work. She is married. She does care for her husband. He has ongoing medical issues. She's happy to testify about all of that. She's never failed to appear. She's willing to wear a GPS monitor if required. Of course, all of the animals in question in this case are now under the custody and care of PAWS or other services. So she does not have access to any animals. She will not be caring for any animals. We're just asking that she's able to bond herself out.
The state would have no objection so long as the defendant is on GPS monitor. The offer is 5 years, DOC. The crimes that are alleged are serious and grotesque. So we believe that just given the nature of the crimes and the amount of time that's on the table, she may be a flight risk. So we would like to make sure that she shows up for the process.
All
And we
right,
ask for no contact with animals.
I'll go with $2,000 signature bond on each count, so you can sign yourself out. GPS monitor, no contact with animals.
Thank you, Judge.
Okay?
Thank you, Judge. She may have to stay in the jail until pretrial can go put the monitor on her.
Yeah,
Um,
pretrial
but
services
we'll inform them.
supervision.
No more than $1 a day, yes, Judge.
Yeah, okay.
The earliest, the latest would be tomorrow morning, I do. Yeah, they should be able to see you by tomorrow morning.
How much is that?
So sign yours, be able to sign yourself
Oh, I'll
out
be
as
able to
signature,
sign-
yes,
okay.
ma'am.
Thank you. Thank you.
She signed it, we signed it again. Goes over everything. Nation. She wanted to sign right there for me, please. Everybody that needs to sign is signed. Your Honor, Tim Gibbs on behalf of Tiffany Cannon. Judge, this is 24 CF 933. We have reached an agreement, if I may. This also includes those two CT cases. I have not heard back specifically from Judge Ward whether he has any objection to this court, the circuit court, taking a jurisdiction of those CT cases. However, you do see Ms. Leon's signature on there representing the state, so I believe the state has no objection to resolving it. Well, the court does have authority and jurisdiction to absorb the jurisdiction from the county court to accept this plea.
Bring her back this afternoon after you get Judge Ward's permission.
We'll come back this afternoon at 1:30. We'll take care of it.
Cantrell.
Your Honor, Tim Gibbs on behalf of Miss Naomi Cantrell. Judge, I believe this is, this was a status hearing for this morning. If I may have just one moment. Judge, we're going to ask to set this for a status hearing on September 26th. We're looking into inpatient options for Ms. Cantrell.
All right, September 26th.
Thank you, Judge. We gotta talk. You and I will talk.
And we got one Friday.
Okay.
Custody, and I'll pick up this rate.
Yeah.
Morning, Your Honor. Justin Harsher on behalf of Anthony Miles, here on case number 19 CF 3289. You're scheduled for a motion to dismiss hearing this morning, Your Honor. The state this morning has advised me that they are going to be filing a traverse in this case. So I believe we're going to try to continue it to the September 26th date.
That is correct, Your Honor, and that is certainly without objection.
All right, we're setting a motion to dismiss hearing, Mr. Miles, for you on September 26th, okay? Thank you. Next.
Thank you, Your Honor.
Your Honor, Tim Gibbs on behalf of Mr. Kevin Bray. Judge, this is 23 CF 2408, 23 CF 2409. I may have just one moment. What I want to do, because we'll modify it. You'd be so kind as to initial first. Yes, sir. Sign right there. There's an extra as well. Today's date, August 29th. Just need to state signature, Judge. Mr. Bray.
This is Kevin Jerome Bray.
Yes, Your Honor.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God.
Yes, sir.
This is 23 CF 2408, State versus Kevin Jerome Bray. You want to enter a no contest plea to attempted trafficking in fentanyl, a second-degree felony, and a lesser-included offense, and also carrying concealed weapon by convicted felon, a second-degree felony, possession of marijuana less than 20 grams, a first-degree misdemeanor, and in 23 CF 2409, possession of a controlled substance, a third-degree felony. Is that correct, Mr. Gibbs?
Yes, Your Honor.
And Mr. Bray, that's what you want to enter a no contest plea to those charges? Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea?
Yes, sir, I am.
Did anyone force you or threaten you to enter this plea?
Yes, sir, they did not.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Gibbs did for you on your case? The court finds the plea is freely and voluntarily entered. The court accepts it. On the misdemeanor counts, in each case, each count sentences you to time served, adjudicated guilty. On the felony counts, in each case, each count, I'm sentencing you to 11 months, 29 days, Okaloosa County Jail. You're to enter and complete the Emerald Coast Life Center, ECLC, followed by 1 year community control, $100 cost of prosecution times 2, $515 court cost times 2, $250 PD fee, continued treatment with ECLC, weekly UAs for the first 9 months following release, random UAs after 9 months, then followed by 1 year probation to complete the same conditions. And you waive all jail credit and a 5-year suspended Department of Corrections sentence on each felony concurrent and adjudicated guilty, all cases, all counts, and the 5-year DOC is concurrent with waive all jail credit, correct?
I don't know about that, Judge. I think it's just waive all the jail credit for this current 1129.
All right, waive the jail credit for the 1129, not the DOC suspended.
Thank you, Judge.
So if you mess up, you'll go for DOC for 5 years, but I'll give you credit for the time you spent in jail. Okay? Okay.
Thank you, Judge. And that 1129, of course, is concurrent.
Yeah, concurrent on all the 1129s are all concurrent. Waive cost supervision.
Thank you, Judge.
And Your Honor, Mr. Bray will be on GPS upon his release at $1 a day. What's the requirement for GPS?
Okay.
$1 GPS.
Okay.
$1 a day GPS.
Understood. Thank you, Judge.
Okay? Thank you.
Good luck.
Thank you.
Thank you.
Oh, Your Honor, I'm sorry, and the GPS may be hooked up prior to his release.
Yeah.
Your Honor, Tim Gibbs on behalf of Mr. Christopher Ellender. Judge, this is 24 CF 264. Did the state have a recommendation for Mr. Ellender's VOP?
The suspended sentence.
Judge, we'll enter denial, and I'll ask to set this for September 26th without subpoenas.
September 26th.
Thank you, Judge.
Thank you.
I'll see you.
Gallardo?
Your Honor, Tim Gibbs on behalf of Mr. Shannon Gallardo. Judge, this is 20 CF 128 and 24 CF 545. Judge, we are set for sentencing this morning on Mr. Gallardo's violations of probation, or violations of probation. Judge, I believe the state actually was going to recommend the probation's recommendation, which was 2 years CC, and then also Mr. Gallardo goes to Bridgeway.
That's correct.
And Mr. Gallardo is amenable to that sentence.
All right, well, is he, there's already been a plea taken, correct?
Yes, Your Honor, he already
All right.
admitted at his prior court date.
All right, I'll sentence you to 2 years community control and require you to go to Bridgeway. Is that for substance abuse
Yes, Your Honor, for
counseling?
substance abuse counseling.
All right. Yeah, adjudicated guilty, I guess, already, correct?
He was, Your Honor.
All right. And so 2 years community control, and I order you not to break the law in the future.
Sir. Thank you, Judge.
Okay. Yeah.
Have a score sheet. Have a seat, and I'll get you started.
Is that concurrent?
Concurrent.
Yes, Your Honor, thank you.
They listen to me when I say don't. They listen to me when I say don't break the law.
Good morning, Your Honor. This is Sonny Rogers before the court on 24 CF 1846. We filed a motion for a bond reduction hearing. In speaking with the state, I informed her that she is unable to post any type of monetary bond, and she has little to no criminal history. We're asking the court to give her an ROR or signature bond. In speaking with Ms. Basso, it appears that she is in agreement with that as long as there's pretrial release conditions, no contact with any of the alleged victims, and no alcohol.
That's correct, Your Honor. The state would have no objection to that if that's acceptable to the court.
All right. She's not looking at any kind of prison time on the conviction?
No, Your Honor.
All
And
right, yeah.
And, Your Honor, she would just ask for a one-time visit with police to pick up her vehicle, which is parked in the yard of the alleged victim.
All right. ROR, one-time visit to get your car, no contact with, is it the victims or any?
Two, Your Honor.
Those two victims.
No contact with the victims.
And we're also asking for no alcohol and pretrial services.
Yeah, no alcohol, pretrial services, and when's your next court date? September 26th. Be back or I'll issue a capias and you'll be back in jail. 1:30.
Oh, 1:30. All right, there you go. Okay, that's fine, Your Honor. Your Honor, this is Terry Ann Zelm before the court on 19 CF 2237. We're going to enter a denial at this time. I'm going to ask if we can put this on for next Thursday. We may have this resolved by then. I don't know. I did provide the state with some pictures just a few minutes ago.
All right, September 5th.
All right. Be back to see you.
Are y'all working on getting those cases resolved that were announced trial?
We got one resolved already.
Your Honor, this is Davin.
Yes, no.
Davin Smelly before the court on 24 CF 1883. We filed a motion to reduce bond. Mr. Smelly is charged with possession of a controlled substance and 2 counts of drug paraphernalia. His current bond is $3,000 total, cash or professional. He is unable to post any cash bond. He is a lifelong resident of Okaloosa County. He has family ties to the community, and he is just asking the court to modify his bonds to ROR or signature.
If we would ask for a $1,000 cash professional, one of the relevant factors is the street value of the drugs that he had. So he has money to buy drugs on the street. He should have enough money to post $100 for a professional.
Is he looking at prison time?
No idea, Your Honor. Well, Your Honor, since he's not looking at prison time,
I
he
got a
is
job
homeless.
waiting on me.
He is homeless, but he does say that he does have a job.
Gulf Coast Wilbert.
Gulf where?
Gulf Coast Wilbert.
Gulf
Coast Wilbert.
Wilbert?
Yes, ma'am.
Gulf Coast Wilbert. There's a job waiting for him
Where
at
is
Gulf
that?
Coast
It's
Wilbert.
a grave digging job here in town.
Judge, if he is homeless, we need to be able to track him down, and that would be the reason we want a professional.
But if he doesn't score prison, maybe
For no bond.
he can't post any type of monetary bond. Like I
Go to
said,
the shelter, to the homeless shelter.
right.
What I'll do is $1,000 signature bond per count. When's his next court date?
The 26th.
No.
All right, be back. Make sure
9/26.
you're back.
Yes, sir. Thank you, sir.
All right,
Can
here.
I get out today?
Now here's your court, right there.
Johnny, before that. Okay, thank you.
Your Honor, this is Christopher James Stearns before the court. I believe it's 29 on the docket. He's before the court on 24 CF 1853. He is charged with possession of a controlled substance, possession of drug paraphernalia. His current bond is $1,000 cash or professional. He's unable to post any monetary bond. He is a lifelong resident of Okaloosa County. He's asking the court to modify his bond to ROR or signature bond or something, pretrial services, anything, but he's just not able to post a monetary bond.
$1,000 signature?
Is that a trustee outfit?
Yes, sir.
How come all these people have money to buy drugs, but they don't have money to post a bond? $1,000 signature. When's you gonna be back in court? September 26th? 1:30, September 26th, $1,000 signature bond.
Yes, sir. Thank you.
All right, that's the court date, okay?
All right, thank you.
Your Honor, this is Brian Velasquez. He's before the court for violation of probation on 23 CF 910. We are going to enter a denial at this time, and I would ask if we could put this on an October court date.
October 31st.
Yes, Your Honor.
Thank you.
All right, Mr. Velasquez, yeah, back out to see you.
Yes, ma'am.
Judge, there's a case that's on the docket, and there's a private attorney here. I don't believe the defendant's going to be here because he's in jail. It's Bunkley. That was on the docket to correct an error. I believe if the clerk is satisfied with what's occurred, I believe there's an amended minute sheet that corrects whatever error in that case.
Your Honor, it's Arquito Bunkley in 15 CF 998. Mr. Durrell wasn't aware he was on the docket as he entered a plea back in July. I think he's actually in DOC at the moment.
What's the error?
The error was the minute sheet didn't have that the sentence here was supposed to run concurrent with the sentence in, I believe, Escambia County.
All right, well, just send me a corrected judgment and sentence. How about that?
Okay, according to her notes, she wants to clarify the county for the case number. That it was supposed to be concurrent.
Yep.
Escambia County.
Escambia County.
Yes, sir.
So it's to be concurrent with 16 CF 11 Escambia County.
That's correct.
Yes.
Okay.
Okay.
That's all I have, Your Honor. Thank you.
Ms. Dudley, not only do you have to take care of your clients, you got to take care of these other attorneys' clients.
Your Honor, if I may have just a moment with Mr. Weeks to inform him of something.
All right. right, this is Anthony Eugene Weeks.
Your Honor, if we could set his case for Thursday, 9/5, for resolution.
All right, September 5th.
Thank you, sir.
Thank
Appreciate you. Thank you, Ms. Rivers.
Your Honor, there's one other case that's listed on the docket under my name. That would be Brandy Weathersby. That would be 20 CF 450. Your Honor, my understanding is that she bonded out of jail on this charge, and then Walton County picked her up and took her over to the Walton County Jail. So that would be why she's not present. I would just enter a denial and request a court date of October 31st.
All right.
Williams, we're going to stack all your females at the front of the list.
That's fine. I've got a civilian, or I've got a non-incarcerated person here for a plea judge. Destiny Martone.
Destiny or Dusty?
Destiny, Destiny. Just put your signature right there. Do you mind if I date it for you?
Ms. Martone, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God. This is 24 CF 1193 and 24 CF 1726, State of Florida versus Destiny Marie Martone.
Judge, on 1193, it's going to be withheld court costs, and on 1726, that's the one sent from low end of the county, it's going to be a withheld probation with the usual drug conditions, drug evaluation and treatment, random UAs.
That's the state's offer.
All right, so she's pleading straight up to 2 degree felonies, correct?
No, we have an agreement that I've written down there.
Says as charged. What does that mean?
Meaning that she's not making a plea to a lower offense, a lesser included.
That's what I just said, didn't I?
Well, I thought you said straight up.
Well, yeah, she's pleading straight up not to a lesser included, is what I said. She's pleading straight up to these charges, not to a lesser included.
Typically, when I say straight up, I mean without an agreement. It's to the court. I'm sorry, I misunderstood.
All right, this is 24 CF 1193, 24 CF 1726. You want to enter a charge, a no contest charge in 1193, Ms. Martone, to possession of a controlled substance, cocaine, a 3rd degree felony, correct? And in 1726, possession of a controlled substance, a meth, 3rd degree felony, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Actually, have you signed it yet? Yeah, you did. You just now.
Yeah, you just
Okay.
handed me the sign.
Did you sign it? Are you aware of the rights you're waiving by entering this plea?
Yes.
Anyone force you or threaten you to enter this plea?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it in 24 CF 1193. Adjudication is withheld, sentenced to standard court costs. In 24 CF 1726, adjudication withheld, 1 year probation, have a substance abuse evaluation, completed recommended treatment, random UAs, standard court costs, cost of prosecution, and PD fee. $1 and waive cost of supervision.
Ronnie, man, you'll have to talk with these folks right there. Do you need, since it's a withheld, you don't need her, okay.
During probation.
Just call them out as you bring them, and I'll pull their file out. Judge, I just need to get her signature on the agreement. Right up here.
What's today's date?
8/29.
There you go.
You're Amy Adcock Hart.
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
This is State of Florida versus Amy Hart, 21 CF 1832 and 21 CF 1530. You want to admit that you violated probation on these cases, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Absolutely.
Court finds the plea is, or admission is freely and voluntarily entered. Court accepts it. Judge you guilty on both counts, revoke and terminate probation, sentence of 90 days, Okaloosa County Jail with credit for time served, concurrent. All outstanding monetary conditions to collections, and adjudicated guilty on both cases, both counts. So I guess you got 90 days in jail, credit for time served. How much time have you served?
Does it count from when I was arrested?
Yeah, all of it counts.
All of it counts while I'll be out. I should have it all credited out.
Should have already done
Yes.
about 90 days?
Yes, sir.
All right. Court orders you not to violate the law in the future. Thank
Yes,
you.
sir. Thank you.
And Judge, just for the record, the state will provide the score sheet later. My calculations put us at 27.6.
All right. Give me that score sheet, too.
Will do, Judge.
Christy Leanne Holly, 21 CF 3096, 23 CF 1405, and 24 CF 961.
Judge, at this point, we don't have an offer in the case, and I'm trying to get some sentencing options for us. So for right now, I'm going to just enter a denial.
Okay. There for what, October 31st?
That'll be fine, Judge.
And as of right now, the offer is going to be 32 months DOC.
Okay. I'll make a note of that.
Okay.
Judge, Ms. Lige is before the court for a competency determination. I've got a copy of the assessment from Florida State Hospital.
I think that was filed already, wasn't it?
It probably has been. I just wasn't sure, so I wanted to make an extra copy for you. Judge, the short version is they have found her to be competent. I did meet with her. I did not notice any issues that caused me to continue to question her competency. I did inquire by email as to whether this was a case that we could resolve with time served and sit. Actually, what we would need to do to keep the withheld is a withheld cost. But she has been incarcerated for about 10 months now at Florida State Hospital, and she was in jail by Florida State. And I may have sent an email to the wrong person.
So,
All right.
yeah, we can work it out if we continue it. We'll get it worked out.
You think we can get it done, say, by the 9th? I mean, by the 5th of September?
Yeah, bring Miss Lige. We need to get her case finished, so we'll bring her back. I don't think she needs any kind of jail time or anything.
The state concurs with Your Honor, so we'll get it worked out.
All right, we'll bring you back September 5th next week,
Okay,
okay?
okay.
And the court finds that she's competent to proceed based on these psychological report. So just, your attorney wants a little bit more time to work out the best possible situation for you.
Yes, sir.
And we'll bring you back, and hopefully you'll get out next week, okay?
Yes, sir.
Okay, thank you.
Okay, Destiny.
Ms. McDonald.
Here's Mr. Williams.
Oh, thank you, Judge.
Is it Kyra McDonald?
Sierra.
Sierra? Okay.
What I've done is I've been tracking what probation.
Sierra McDonald, 21 CF 2972. Would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission? Are you aware of the rights you're waiving by entering this admission that you
Yes, sir.
violated? Your right to a hearing before me, right to remain silent, right to make the state prove its case. You're aware you're waiving those rights?
Yes, sir.
Okay. Did you read this plea and sentencing agreement form and sign it?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Judge you guilty. Place you on, is it 1 year community control?
Yes, sir. What?
After finishing the original terms of probation, is that right?
No, Judge, she will start 1 year community control. Think of it as 1 year community control as a condition of her current probation, is what I understood probation was asking for.
I don't even know what you're saying, Mr. Williams, but I think, sure you going, if you want to reinstate her with the next year on community control?
Yeah. That sounds more, that sounds better.
Here, let me show you what the,
It's okay.
Yeah, because she's on probation, Your Honor, till July of 26, so just reinstate with the next year on community.
Yeah.
Okay, we got it.
Judge guilty. Any violation of any VOP fee, PD fee, cost of prosecution, all go to a judgment, or you can pay it within the time of your probation, and then it goes to judgment. And waive cost supervision. Okay? And court orders you not to break the law in the future. Thank you.
Thank you. Do I check in 24 hours?
Judge, I'm going to enter a denial for today.
October 31st, thank you.
Thank you, sir. I'll have to file that for you. We won't be able to hear that today.
Mr. Hand. Now, please, sir.
This is 20 CF 904, Richard Thomas Hand.
Judge, Mr. Hand's actually here for an arraignment, but he wound up on the morning's docket as well as the afternoons. We're still working out a plea agreement on that. The state was not prepared to make an offer yet. I have met with Mr. Hand, so I'm just going to enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions, and demand trial by jury.
All right, he's charged with, is it possession of more than 20 grams of marijuana?
Judge, actually on 1703,
He's charged with trafficking in methamphetamines.
I have 20 CF 904. I don't have the other case number.
I see, because I believe he's also up for arraignment this afternoon, if I'm not mistaken.
Okay, that's the trafficking in fentanyl?
Yes, so he's here for the VOP, but also this afternoon for the arraignment on the trafficking.
Meth?
Yeah, methamphetamine.
it's methamphetamine, Judge. And then count 2 is possession of cocaine.
Okay, well, he's pled not guilty, so we'll put him down for, we'll say November 4th and move him up if you can get it resolved.
Now, Judge, I just want to clarify, because they haven't opened a file for me on 2020 CF 904. We are appointed on that case?
Yes.
All right, thank you, Judge.
Oh, I'm sorry. We'll put him on October 28th pretrial. Thank you. Thank you, Ms. Ann.
Thank you, sir.
Next will be Keaton.
Okay.
This is 21 CF 2013, State versus Colton Keaton.
Yes, sir. Judge, I don't think I have an offer on this one yet. I did speak with him, though, and he may have a defense on it. I'll just enter a denial for right now. If the state's got an offer they want to make, please send it over.
October 28th, if you get it resolved, move him up.
Judge, this is a VOP, so you'll want to set it on VOP date.
31st, October 31st.
Thank you, Judge. Pulling some more.
Hughes. Hughes.
Give me just 1 second, Judge. This is going to be a plea.
This is 24 CF 038 and 24 CF 443, State of Florida versus Jonas Hughes.
Freaking diabetes makes my hands so dry. Yeah, right there.
Just if we can address
Sure.
the restitution to go to collection.
Yeah, that's fine.
It was,
Do we have an amount on it?
I was looking for the amount. It's over 4,000, I know. Restitution rate.
The cost of the repairs go to collections. All right, so you'll get letters from collection companies, and because it's being imposed by the government, if it's not paid, or if you don't make regular payments, you could wind up your license suspended.
Is he admitting violation of probation?
No, Judge, this is one that was passed from the 26th, I believe.
Oh.
Or he's entering pleas to just some other cases.
That's the score sheet. Thank you.
And Judge, this will be a down departure as a legitimate unforced plea.
All right, in 24 CF 38, do you want to, Mr. Hughes, you want to enter a no contest plea to burglary, is it of a dwelling with damage? Is that right, Mr. Williams?
That's correct, Judge.
A life felony, count 1 and count 2, grand theft, more than $750, less than $5,000, a third-degree felony. In 24 CF 443, plead no contest, burglary of an unoccupied conveyance, a third-degree felony, and count 2, petty theft, more than $100, less than $750, a first-degree misdemeanor. So you want to enter a no contest plea to those charges, correct? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
No.
Court finds the plea is freely and voluntarily entered. Court accepts it. On each case, each count, each case and each count on the felonies, you're judged guilty. Sentence to 20 months Department of Corrections on each felony count concurrent. Standard court costs, cost of prosecution, PD fees, credit for all time served, concurrent. $4,268.55 restitution to Simply Vapor of Crestview, otherwise to collections. On the misdemeanor count, you're sentenced to time served concurrent, adjudicated guilty, all cases, all counts. Okay?
Okay. All right, good luck to you.
Thank you.
Judge, this is Kelly Hutto. Mr. Hutto's here as for a bond hearing. Judge filed a motion for bond reduction on him. He's been incarcerated since his arrest. His current bond is $20,500. He's not able to make that. He's requesting a bond. The original ad put a bond of $5,000. I've got a note here from him asking that he be able to get a signature bond so that he can pay to get his car out of impound. He's been advised that he's on deck to get his license back, and his nephew, is it Danny Hayes that's
Yes,
coming here?
brother-in-law.
Okay, is coming to show proof of ownership of the catalytic converter and fill out a statement. Is he supposed to be here today, or is he coming in my office
Yeah,
later?
you come to your office.
Okay. He apparently tried to go to the state attorney's office on it yesterday, but they were closed. He's self-employed as a home remodeler. He's lived in this area for 20-some-odd years. We're asking that the court give him a signature bond.
Judge, what's alleged is that he was in possession of a catalytic converter. Shouldn't be. He said he was the owner, but in the police report, this officer stated there was clear cut marks on there. So along with the catalytic converter, he was caught with illegal drugs. He's driving on a suspended license. So it appears that he's in possession of the catalytic converter to buy drugs. So we're going to ask for a cash professional bond. So we can ensure that the defendant shows up for the process. Apparently there's a car without a catalytic converter.
Is he looking at prison time?
Excuse me, Judge?
Is he looking at prison time?
The current score sheet that I have, Judge, has a least permissible sentence as 23.48 months.
How much time has he served in jail?
Judge, I've got him arrest date on both of these as 7/18/24.
Has he got a prior record?
Judge, I don't actually have a copy of the score sheet
Yes, sir, Your Honor.
as yet.
If I may,
Mr. Berry seems to know.
what I have on the score sheet is, we don't have time for me to go through all of them.
All right, I'm gonna leave the bond the way it is. Thank you.
Do you want me to hang on to this? Excuse me?
How many more we got, Steve?
Got it.
That is,
Are we gonna address his?
has he got,
Judge, I think he's got an arraignment scheduled for today as well. I'll enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions, and demand trial by jury.
what's he charged with on that?
That is the case that we just had the bond hearing
Okay.
on, Judge.
Thank you.
And for the record, Judge, the state attorney's office was open yesterday from 8 to 5.
All right.
I tell you what, don't take him back. I may bring him back and redo the arraignment at 1:30, okay? He wants to talk with me beforehand, so I'll meet with him back in the conference room. Yeah.
Thank you.
Can you get me the score sheet for the discovery before his arraignment? Actually, in like the next 5 minutes, because he's wanting me to talk with him and go over that with him before his arraignment. Ordinarily, that doesn't even start until about 15 days after arraignment, okay? They're very quick over here, so if they can get it to me, I'll put it on the computer and I'll come back and look at it with you, okay?
And I believe my assistant's watching currently, so she'll get discovery and the score sheet over ASAP.
Is this John Joseph Keipel, is that right?
Yes, sir. Mr. Keipel was passed to today for a possible resolution. I had made a proposal. I haven't heard anything back on it, though. He was originally arrested and charged or arrested with a trafficking in fentanyl. That was, there's no lab, that found no controlled substances. We don't have a lab report on the suspected cocaine.
You're speaking about the wrong case. John Keipel, it's aggravated assault with a deadly weapon.
You're right. I'm looking at my old notes where I was looking at somebody else's.
Yeah, the offer is going to be 20.55 months DOC.
All right, here's what we'll do. I'm going to take depositions in it, okay? And all right, Judge, let me just go ahead and continue him until the 28th, and I'll take depos.
All right, October 28th.
Judge, Mr. Mason's before the court for a bond hearing. Mr. Mason, your mother's here.
Yes, sir.
And Judge, just so it's on the record, he wants me to be able to communicate with his mother about the status of his case.
Okay.
So Judge, all right. So Judge, I filed a motion for bond reduction on him. Here we go. He's been incarcerated since his arrest on July 30th. He's got bond of $1,500 cash or professional. It's not a huge bond, I'll grant you, but he's not able to raise the money to a professional bondsman. He's requesting a signature bond. He is self-employed doing repair work. He resides at 5453 Clint Mason Road in Crestview and has lived in this area for 38 years. I spoke with his mother earlier. She showed up and my understanding is still present in court yet. So I could call her to the stand to, establish bona fides on any of that. Is he going to be residing with you, ma'am, or? She's nodding her head, yes.
Is he looking at any prison time?
A second, Judge. So he has 3 cases that are open with my office. So he was already out on bond when he picked up new charges.
He was out on bond when he picked up new charges?
That's correct, Judge.
I'm gonna leave the bond the way it is. Thank you.
Do we have informations filed? Hang on a second. I may be able to save you another trip. Do we have informations filed on all 3 of his cases? If so, I'll just go ahead and arraign him.
I'm not sure.
Okay, all right. We'll just bring you back on the 5th then for an arraignment. Okay.
Mr. Moore. Wait a second. Tyler Moore.
Okay.
Do we have an offer on Mr. Moore for the VOP?
Not at the moment.
What are we doing? Are we arraigning him or what?
Judge, this is a VOP case. I just asked the state if they had an offer on him. Mr. Moore's looking to enter a plea either for reinstatement, community control, or county jail. I think the recommendation was incarceration, but he scores low, Judge. Hang on a second. By my calculations,
Just over 22 points.
yeah.
So if he wants a straight up jail, do 60 days.
It would be, he would score 28.8 with the additional 6 points. And you said what, 60 days? Okay. Judge, we'll do that.
Right, it's Tyler Lee Moore, correct?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God.
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
You put your hand. Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Go ahead and sign there. And just for the record, I met with him last night and went over the boilerplate on the form, including his rights.
All right, did you read and sign this admission form?
Yes, sir.
And you're aware of the rights you're waiving by entering this admission?
Yes, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Is it just sentence him to 60 days county jail?
Yes, Judge.
All right, the court sentenced you to 60 days county jail, credit for time served. Is there any, is that a withheld or adjudicated?
It'll be adjudicated because it's incarcerative.
Adjudicated, and credit for time served, and standard court costs, public defender fee, auto collections.
And I'll have this score sheet for your honor when we come back for break.
All right, thank you.
Yes, sir.
Thank you. All right, Mr. Moore, good luck to you.
Do we need to take a break, or do we have any more?
I've got another file on a Kelsey Murphy.
Who's Kelsey? Come on
That's
down.
this afternoon. I have a bond.
Just kidding. She's here.
Okay. Judge, this was originally scheduled for a bond motion today. She's out of jail. And I'm sorry, we didn't cancel the hearing.
So this is a reverse bond motion, in other words, put her in jail?
No, Judge, we'll just cancel the hearing. I think that she's scheduled for arraignment, though, this afternoon. So if looks like an information was filed back on August 9th, so I'll just go ahead and arraign her now if the court's okay with that.
All right. And is that the possession of controlled substance without a prescription?
That's correct, Judge.
All right.
State has an offer too, Judge.
Oh, what's that?
It's going to be an adjudication. Credit for time served, 6/15. It appears from my notes that FDLE is back and it's positive.
Okay. So the offer, you would be adjudicated, so you'd be a convicted felon, all right? But you wouldn't do any probation, any additional time, it'd be time served, and you would pay the minimum court cost on a drug case, which is $515 plus a $100 FDLE charge. Okay? There'd also be $100 cost of prosecution typically, and a $150 office. It doesn't go to me. I don't know what they do with it.
You want to do that?
Yes, sir.
Would you please, this is Kelsey Leanne Murphy, 24 CF 1586. Would you please raise your right hand to be sworn? Swear the testimony you give for this court is true, so help you God.
Yes, sir.
And you want a no contest plea to the charge of possession of a controlled substance without a prescription, a third-degree felony. Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you to time served in the county jail, 615 court costs, $100 cost of prosecution, $150 PD fee. You got 90 days to pay it, or it goes to collections. Okay?
Yeah, they've got a fingerprint.
And I have a score sheet.
Next.
Judge, the only other person I had on docket this morning was Miss Alicia Bullock, I believe for an order to show cause from the state on why she hasn't been going to the jail on the weekends like she apparently agreed to do. Don't see her, Judge.
She was supposed to go to jail on weekends.
I forgot about you.
So she was, court members, a couple months ago, we worked out a deal for her to do jail on the weekends. She apparently has not been going every weekend like
She
she's supposed
had
to.
that health problem and all that kind of stuff.
I'm sorry, Your Honor?
She the one with the health problems? She could.
She has some health problems. However, all I have right now is that she is apparently not going to the jail every weekend that she is supposed to. And I do not know if she was specifically noticed to be here today. I know the state did file a notice of hearing on the issue, but I do not know.
No bond capias, I guess.
I would ask for that, Your Honor, because she's missed most of the weekends, and I
No
gave her
bond
the-
capias.
Thank you.
Judge, I do have one I can call. If you'll recall, Amanda Lawson was not in court at our pretrial conference. She is in court this morning. She approached me this morning, and she's indicating that she was not aware that was her court date. So what I'd ask the court to do is withdraw the capias and just set her on 10/28.
What is it, Lawson? All right, I'll withdraw the capias, be here October 28th, okay?
Thank you, Judge. All right, ma'am.
Melanie, are they here for arraignment?
And I believe Mr. Arnie may be dismissed. We resolved his cases.
Where's Mr. Arnie at?
He's the one in the green stripe.
Come on up.
His attorney's Mr. Durrell, and I don't see him on, it was a hearing.
And you're dismissing the charges against Mr. Harney?
No, Judge, we've resolved the case.
Resolved it? Okay, well, you're free to go.
Thank you. Thank you.
Mr. Kimmons, come on up. Is he here for arraignment? Mr. Kimmons, did I tell you not to come to court with short pants before? If you do show up in court in short pants, you're going to go to jail next time. All right, he is here for an arraignment. Mr. Williams? He's charged with what?
Judge, I got him as a possession of controlled substance, methamphetamine, and possession of paraphernalia. Does the state have an offer in it?
Yes, adjudication, 18 months drug offender probation, 615 substance abuse evaluation treatment. The reason for this is allegedly he was running around in front of cars on I-10 or on the ramp of I-10, so that's a danger. So we've got to figure out why he's doing that.
Give me just 1 second.
Around I-10 ramp. You know how you go on a ramp on an interstate or an exit from interstate, and there's always like one shoe laying there. It's like one shoe. There's always like one shoe. That's where they're coming from. You run around here and,
We want to avoid that.
yeah.
Yeah.
I'll tell everybody a story sometime. Judge, I'm going to go ahead and just enter a plea of not guilty on his behalf, if the court would instruct him to meet with me.
All right, get with Mr. Williams, and we'll set him for October 28th.
Thank you, Judge.
Don't wear short pants, you're
Yes,
gonna
sir. I apologize, sir.
go to jail.
All right. I'll see you then. Mr. Kimmons, this is your copy, sir. Okay.
I think that's everybody.
Judge, everybody else in the courtroom is either, well, is not a defendant.
All right.
So now we got 1:30 detention hearings?
No, 12:30, Judge.
12:30, I'm sorry, 12:30,
Yeah.
okay.
See you then.
You at 12:30.
Are you guys